So those of you that don't know, I am Mike Powers. I'm the Chief Operating Officer for KS Management. We do these seminars for you guys as board members, just as more of our commitment to education for you. We do the magazines, we try and do these seminars regularly. And I want to officially tell you guys tonight that we're doing these seminars monthly now instead of quarterly. So we're going to set them. It's going to be the second Wednesday of every month. That way it's just a set schedule. You know, you can plan your lives around it because I know you focus on this and make your schedule around these seminars. So those will be going forward that way. And at the end of each seminar, we're going to tell you what the next seminar is, so you know ahead of time and can register for it right within this one. That way it's just a little more transparent and easy to go. So with that, I'll introduce Mike. He's here too. He's one of our association managers. I don't have to give my normal spiel of the camera. So cameras in the center of the table, you guys both know it'll follow you if you move or talk. So no whispering side comments to your neighbors. And then our presenter today is Amy Smith, and she is getting situated up there. And I will turn it over to her.
Thanks, Lee. So as I said, my name is Amy Smith. I'm an attorney with McCower, Abbott, Guerrero, Winder, Bulmer, and I'm here to talk to you today about the Michigan Homeowners Energy Policy Act. There's my contact information. If you have any questions, feel free to go to our website, call me, email me, if you have any follow-up questions after today. And since I'm an attorney, I have to tell you that this is just general information. This isn't legal advice on any specific situation. So if you do have any specific situations that you need, guidance on, feel free to reach out to us and we can talk about that. All right, so this is a new act that is going into effect. It's called the Michigan Homeowners Energy Policy Act. It was approved by the legislature last session. It was signed by the governor on July 8th of 2024. The way that it was passed, it goes into effect on the 91st day after the adjournment of the 2024 session, which was on December 31st, the last day of the year the legislature adjourned. So this act will go into effect on April 1st of 2025, just about 3 months from now. Now, the purpose of this act is to invalidate certain provisions in a homeowners association's governing documents that prohibit two categories of things, and those are energy saving improvements or modifications. And it also allows the installation and operation of solar energy systems without what they call undue restriction. So there's two different categories of things addressed by this act, and we'll get into what those are, what those mean, and how it will apply to your association going forward. One of the key dates is, or one of the key provisions of the act is that every association in Michigan is going to be required to adopt a policy regarding solar energy systems. And the time frame to adopt that is going to be 1 year from the effective date. So April 1st of 2026 is when your policy needs to be in place. However, the act is going to go into effect and you still need to be aware of how to treat these sort of modifications as of April 1st of this year. So you still need to follow it for after April 1st, but you don't need your written policy adopted for 1 year after that. Now, I know that one of the questions that we had received ahead of time was, the act uses the term homeowners association. Does that apply to a condo? So this is not part of the Condominium Act. This is a totally separate act, and they do use the word homeowners association. However, that's not a defined term, and there's really no law that controls subdivision associations that people that we traditionally think of as a homeowners association. So the act is intended to apply to any community association, which is a condo or a subdivision. So long story short, even if you're a condominium association, this will apply to you because homeowners association is not defined, and it's intended to apply to condos, and it also will apply if you are a subdivision association. Right. All right. So there's two categories of things, like I said, that are addressed by the act. The first one is an energy saving improvement or modification. So that's defined as to include, but is not limited to, things like clotheslines, air source heat pumps, ground source heat pumps, insulation, rain barrels, reflective roofing, energy efficient appliances, solar water heaters, electric vehicle supply equipment, energy efficient windows, and energy efficient insulation materials. So there's a lot of things that are encompassed there. And these are all considered energy saving improvements or modifications under the Act. And again, there's going to be different treatment for those things. It could also be anything that's an energy saving improvement. So there is a little bit of the door left open for other items to be included. I think the definition is pretty comprehensive and identifies really what is intended to be addressed by it. So since it's pretty comprehensive, I can't really think of what else might apply, but it's theoretically possible that it could be something else. And then a solar energy system is defined as a complete assembly, structure, or design of a solar collector or solar storage mechanism that uses solar energy for generating electricity or heating or cooling materials. So this is typically what you would think of as a solar panel, but it's really any solar energy system that uses solar to generate heat or energy. One of the key provisions of the Act is that it does not apply to shared roofs or common areas. So as it relates to both categories, the energy saving improvements and modifications, as well as the solar energy system, the provisions of this Act don't apply to installations in common areas or shared roofs. Now, keep in mind, even if your community is almost solely composed of common areas and shared roofs, it still says you need a policy. So every association needs a policy. That's very important to reiterate, even if this may not even change anything for your community. But I think that the way it's drafted, and as we talk about this, I think you'll see that every community is probably going to be impacted in some way here. And I'll get into that later and why I say that, but there's probably some impact on almost every community that I can think of. Now, a shared roof is defined as a roof that serves more than one unit, including, but not limited to, again, a contiguous roof that serves adjacent units. So any roof that is covering any adjacent unit, if there's a duplex, maybe you have 4 units in your building, like Bob's community, anything that has a roof that's connected that covers more than one unit is considered a shared roof. So the provisions don't apply to that. So really, the application there is going to be in your more traditional subdivisions and site condominiums. This is going to have much more of an impact on how they need to review these kind of modifications as it relates to roof installations. Because if you only have shared roofs in your community, then you may not have to allow any of these installations in those areas. Now, a common area, that is defined as a portion of a building, land, or amenities owned or managed by the association that is generally accessible to all members. They give some examples, which are hallways, stairways, outdoor open spaces, or common amenities. Those are pretty obvious to me. What is a common area does get more complicated as it relates to each community and how their documents are drafted, especially when you're talking about attached condominiums, apartment style, townhouse style duplexes. It gets more complicated. What is really a common area that meets both prongs there, which are generally accessible to all members and owned or managed by the association. So we can't, if you're in a condominium, you can't just think of common elements, because we have to look at, is it generally accessible? If it's a general common element, probably. But if it's a limited common element, that's a lot trickier. And, you know, can you restrict it in a limited common element area? It depends. So we'll talk about that more. And so really, ultimately, how this act applies to your community just depends on your makeup and how your documents are drafted. And again, in a subdivision or a site condominium, the application of this is going to be much more straightforward. All right, so first, as it relates to the energy saving improvements and modifications, I want to address that first. So again, those are the category of things like clotheslines, electric vehicle charging stations, rain barrels, not solar panels. That was the energy saving system. I'm sorry. But the energy saving improvements and modifications, the act says that any restriction on them is invalid. So the association cannot restrict, can't put any limitations on, can't put any sort of preference on, whether that's color, location, those type of things. Any restriction that addresses one of those energy saving improvements or modifications are invalid. So if it's in a common area, then there's probably nothing that, I'm sorry, if it's not a common area, there's probably nothing you can do about it. So if it's within an individual unit, a limited common element space that doesn't have any modifications to the general common elements, that's going to have to be allowed by the association. If you're in a site condominium subdivision, anything within that lot or unit can't be restricted. So really, no restriction is going to be valid for these unless it requires some sort of common area modification, or obviously if it's in a common area or on a shared roof, then it can certainly be restricted. So in that, like in an attached or townhouse style community, this may not apply much, if at all. If the unit's only airspace, then people can do whatever they want within their unit. But if they go outside of those, perimeter walls and they're modifying electrical, utilities, those type of things, then at that point, the association may be able to restrict it. But again, it really is going to depend on how your documents are drafted. And does it require a general common element modification? So things like rain barrels, clotheslines, those are more straightforward. Where I think that this analysis gets more complicated is with electric vehicle charging stations. I know in our practice, we've gotten many, many questions so far about, do we have to allow these? And with the EV charging stations specifically, it's really important to make sure that you're doing a careful analysis of your documents. What's going to be modified? What modifications need to be made to allow it? Is it only modifying a part of the electrical system that the co-owner has control of, not the association? So it's not an easy analysis, and so I would just caution you to be careful in those situations. If you are an attached condo style, make sure that you're being careful about trying to restrict those type of installations. Now, the Act also invalidates anything in bylaws, rules, or policies that restricts what it says are auxiliary changes needed for installation of the energy saving improvements or modifications. This one is very big. So I just mentioned this so you're aware of it, because auxiliary changes is not defined. So I tried to think of some examples. That could be upgrading an electric panel if you needed a higher capacity for something like a solar water heater, or maybe the EV charging station. Maybe someone needs to put reinforcement up to hang, their clothesline to support the weight of the clothes, that kind of thing. So really, auxiliary changes can't be prohibited, but that's where the drafting of this act is, a little bit problematic, because it also says that it doesn't apply to common areas or shared groups. So if these changes modify general common elements that meet that common area definition, then the association should still be able to restrict that, require approval, those type of things. But again, that really depends on what's being done and what your documents say is a common area, and what the co-owner has exclusive use of, and what the association maintains and insures. Insurance is a big consideration, especially when it comes to those EV charging stations. So again, the bottom line is energy saving improvements and modifications cannot be restricted within the unit or a limited common element area if the co-owner has exclusive use and they are responsible for it. If the association is responsible for it, we'd have to do more of a case by case analysis of whether the act allows the association to totally prohibit that or not.
Hey, Amy,
Yeah.
Real quick, we had a slight little fun issue with our links. So we had 2 different waiting rooms going on. So
Oh, okay.
and a ton of people right now. So there's 15 more people joining us.
Okay. Yeah.
So I don't want to ask you to start over, but
That's
I
fine.
might have to recap a little.
Yeah, I can recap.
So
And that's kind of the bottom line for these. The solar panels and solar energy systems get a lot more detail under the act, so I can maybe kind of quickly recap here what we had talked about.
Sorry, they're piling in now. So that explains why there wasn't a bunch of people at the beginning.
Right.
Chris texted me because he was on the link and he's like, "There's a bunch of people here. Are you guys here?" Oh, okay. Those of you just joining us, thank you. Sorry about the issue with the link. We had already started, so Amy will do kind of a quick recap here and then jump right back into the presentation. If you have any questions that come up, we're just kind of waiting to save all those to the end where Amy will do a Q&A. So I'll reintroduce Amy. Amy Smith from McCower Bate, we're a Wagner Homer. I get it right?
Yes, thank you. All right, thanks everyone. Okay, so I'm Amy Smith again from McCower's office, and I'll do a quick recap. I think that some of the stuff that we talked about was important, so I'll do an overview of what we've addressed so far. So we're talking about the Homeowners Energy Policy Act. So this is a new law in the state of Michigan that was passed last year and is set to go into effect on April 1st of this year, 2025. The act and its requirements will go into effect on April 1st of this year. One key component of the act is that you need to, every association in the state of Michigan needs to adopt a solar energy policy within 1 year of the act's effective date. So even though you need to follow these restrictions as of April 1st of this year, you have a full year to get your policy into place. But it's important to know that you will eventually need to do that by April 1st of 2026. So the key aspect of this act is that it invalidates certain provisions in homeowners association governing documents that prohibit energy saving improvements or modifications. And they also invalidate any provisions that would prohibit or restrict installation and operation of solar energy systems without undue restrictions. So there's two different categories of things that are addressed under this act. And we were talking about the first, which is the energy saving improvements or modifications. Under the act, those items are defined as things like, but are not limited to, clotheslines, air source heat pumps, ground source heat pumps, insulation, rain barrels, reflective roofing, energy efficient appliances, solar water heaters, electric vehicle supply equipment, energy efficient windows, and energy efficient insulation. So it's a pretty comprehensive definition. It's not, it's exhaustive. There could be other things, but this is a pretty comprehensive list of things that would be considered an energy saving improvement or modification. And the act also addresses solar energy systems, which are complete systems that are designed to allow a solar collector to use solar energy to generate electricity, heating, or cooling materials. So the primary one that we think of when it comes to that is solar panels. It's not necessarily limited to a solar panel, but that's essentially what the majority of this is designed to apply to, is to allow installation of solar panels without the association being able to prohibit them, except in very limited circumstances that we'll get into later. So a key provision of this act is that it does not apply to common areas or shared roofs. So a shared roof is any roof that serves more than one unit. So any sort of attached condominium, any roof that is, connected and covers more than one unit is going to be, the act does not apply to installations in those areas. So really we're just talking about things like detached condominiums, your traditional subdivision or site condominium, where there's one roof over the individual unit. And then the act also does not apply to common areas. Now, this definition is defined as a portion of a building, land, or amenities owned or managed by the association that is generally accessible to all members. And the examples that they give are hallways, stairways, outdoor open spaces, or common amenities. So those, are pretty straightforward. If there's like a clubhouse, a common hallway that serves more than one unit, those are obviously common areas. And then where this analysis is going to get more complicated, and depending on the type of community you're in, is, when there's attached condominiums or something, and that we're talking about the general common element, electrical, or, other areas that aren't as straightforward. So really, to know how this applies to your individual community, it will require an analysis and a close look at your governing documents. And it just depends on what the makeup of your community is in terms of what's a general common element, what's a limited common element, what's the actual unit itself. In a site condominium or a subdivision, it's going to be much more straightforward how this act is applied in those situations. But again, you got to really look at how things are defined, because the common area definition under the act is not necessarily linked to the terms that you see in a condominium's governing documents like general common element or limited common element. They focus on, is it owner managed by the association? Is it generally accessible to all members? Those are the two prongs that it needs to meet to be a common area.
But I think one of the things that you mentioned is a lot of questions I've seen so far is like a condo association with multiple units, like open doors, multiple units sharing one roof, and the fear that someone can then throw solar panels on that, and that is explicitly included in this.
Yes,
So
that's very, yeah.
Well, we still have to have a policy.
You still have to have a policy, and it's, one of the things that we mentioned, we haven't gotten into too much detail about, but we kind of is like, even if you only have attached roofs, there's probably some area of your community that the co-owner has use of that they're responsible for. Things like decks, balconies, patios. Those are probably not going to be generally accessible to all members. So in those situations, it's quite possible that the co-owner is able to install one of these energy saving improvements or modifications, or potentially the solar energy system in that area. But to figure out if there's anything that you can do to prohibit or restrict or even require approval for it, we're going to have to look at, does it require a common element modification? Because if you're hooking into, general common element electrical, if you want to, use a portion of the general common element land for this installation, then they're not necessarily entitled to do that. A co-owner is not allowed to modify, common areas and those general common element things without the association's approval. So if they were to be able to fit something like a clothesline, like right in their patio, and it's their limited common element space, it's unlikely that you could prohibit that. So that's why, like in every community, there's probably going to be some area that is impacted by this, even if it's not, you don't have to allow solar panels on the roof. There's probably something that you're going to have to allow that you didn't necessarily allow in the past, or you could at least require approval for that you can now. So as it relates to those energy saving improvements or modifications, again, those are not the solar panels. Any restriction is invalid. So any restriction on like color, placement, if it's solely within the unit or a limited common element area they're responsible for, it's unlikely that you're going to have any say in it. It's likely going to have to be allowed. In a site condominium or a subdivision, if it's within the co-owner's unit or lot, that is going to need to be allowed, and the association can't restrict it. That's not quite the same with solar panels. That's important to keep in mind, but we'll get into that next. The key analysis is really, does this require a general common element modification when looking at if something can be restricted or potentially prohibited, or if the co-owner can do it without any sort of approval. And the one question that I thought was important to address that we had gotten ahead of time is, this does apply to condominiums as well as subdivisions. So the question was totally correct in pointing out that this act doesn't define the term homeowners association. And I know that, traditionally a lot of people think of a subdivision when they think of something that's called a homeowners association. But there's no restriction in this act that specifies it only applies to a subdivision, and it's clear, especially from the legislative history, that this is intended to apply to condominiums. So even though they use the term homeowners association, it's still going to apply to the condominium association, and that includes the restriction that, the requirement that you have to have a policy. So even if you're sitting there thinking like, the only thing I might need to do is allow a clothesline on someone's patio, you still have to put a policy in place.
So this impacts every association.
Every association.
If you're questioning that, you're impacted.
You have to adopt a policy. And just real quick before we move on to the solar panels, I just want everyone to be aware of this. There is a lot, and I'll say there's a lot in this act that's not very specific about how an association will implement this. So I think that a lot of the drafting of this act is focused on allowing installation, allowing people to put these things up, but it doesn't really address too much or give too much guidance on how an association really implements this and how they, can operate on a day-to-day basis working within this framework. So one of the things that's mentioned, but isn't really defined or addressed or discussed, is that it also says that the association can't restrict any auxiliary changes needed for installation of these energy saving improvements or modifications. And, it's a little unclear how that applies because the act also says, well, it doesn't apply to any common areas or shared roofs. So regardless of whether someone wants to say it's an auxiliary change, if it's in a, common area or on a shared roof, you don't have to allow it. So really any of these auxiliary changes that you need to allow are still, restricted to being within the unit and, probably a limited common element area. And I know before you guys got on, I was trying to think of some examples. Things that I thought of are maybe like electrical panels to upgrade electrical power supply for things like EV charging stations or solar water heaters. Maybe if you needed some reinforcement for a clothesline, new ductwork for these energy efficient appliances. Those are all auxiliary changes. But again, if it's in a truly common area, it doesn't necessarily need to be permitted. I will say that, in general, I would maybe start thinking about not necessarily saying, no, you can't do this, but you can still require approval, make sure that they are responsible for all the costs, any damage, if you want to make them insurance. So those type of restrictions you can put into place if the association has control over the common areas that are being modified. But I think, the point of this is really to allow these installations. So it's definitely something to keep in mind and work through as you start getting these modification requests and seeing, what people want to do. So we'll save questions till the end. But, long story short, with these energy saving improvements or modifications, again, the association can't restrict them. We've had people ask, can we say that the clothesline can only be 12 feet long? And the answer is obviously no, because that would be a restriction of it. So as long as it's within their, exclusive use areas, there's no restriction that you can put on it. And again, solar panels that we'll talk about next are different. And one of the examples that I was talking about that are going to require some specific analysis of your governing documents, and many are electric vehicle charging stations. We've been seeing a lot of requests and associations that are dealing with requests on those, whether it's in, maybe they're attached units, but they have their own individual garage. If there's, maybe an underground parking area, that's a general common element parking area, that's probably more straightforward. But, in a lot of these attached units, the garage is either a limited common element or it's maybe even part of the unit. So those get more complicated and do require a detailed and thorough thinking through of like, is a general common element area really being modified? Even, in many situations, it could be that, the electrical modifications are only after the meter and the co-owner is responsible for that. So it may be hard to restrict those if there's no common electrical wiring that's being modified. So that's why I know it's really important to look at on a case by case basis and think through what's really being modified. All right, so moving on to the solar panels, because this is addressed in much more detail in the Act. So again, keep in mind that if you have a shared roof, none of this is going to apply to you. This is really for detached condominiums, if they don't have general common element roofs, site condos, subdivisions. So this aspect of it is very detailed under the Act, but it may not apply to your community at all, like those energy saving improvements and modifications might. But keep in mind, and we're going to talk about this, I think on the next slide, the Act still has significant statutory required language that must be in your policy. So if you draft your policy that you need to draft and it needs to comply with the Act, it's going to tell you a bunch of things that it must say. And it might be confusing to you and your community, and rightfully so, because you're going to have this policy that needs to get sent out to everyone saying, if you're going to install this on a, not shared roof, this is what you need to do. And it is true that your policy is still going to have to say all of these things, even if it doesn't apply to you. So it is, it is what it is, but it's just something to be aware of, because we've already had requests from boards saying like, we only have shared roofs. Can we just cut this out? And unfortunately, the way this is drafted, you can't, because the act says your policy must state that it lists out all of these things. And so your policy is going to have to include those, and I'll talk about that next. So any restrictions on installation of solar panels or these solar energy systems, the act invalidates any existing restrictions that totally prohibit them. And it's very specific about what conditions can be imposed on them, and those are minimal. And we'll talk about those in a minute. And again, the association control is limited to being, shared roofs or minimal restrictions within a lot or a unit. All right, so let's talk about the solar policy. So every association is required to adopt this policy within 1 year of the act's effective date. So like I said, by April 1st of 2026, you must have this in place. Well, it's going to go into effect on April 1st of 2025. Your policy, you have 1 year to adopt your policy. So unless something changes with the law, obviously, but yeah, you have a year to adopt your policy, even though you have to start following all this stuff on April 1st of this year. So the policy requirements are that it can't conflict with any other laws. It must allow installation on roof faces or yard areas, and it effectively prevents the association from requiring any specific technology, make or model, as long as the system meets the definition of a solar energy system. And so I don't want to keep repeating this, but just keep in mind, if you have a shared roof, you can still place those restrictions on it if someone wants to do it and you want to allow it. You can say, no, we're just talking about the non-shared roofs at this point. And your policy must state certain things. So like I just said, there's a long list of things that your policy has to state, regardless of whether this applies to your community or not. So it must say that when an association reviews an application for a solar energy system, they will not do any of the following. And that's inquire into a member's energy usage, impose conditions that impair the operation of a solar energy system, impose conditions that negatively impact any component industry standard warranty. You cannot require any post-installation reporting. You cannot require a fee for submitting an application that is more than what you would charge for any other modification request. You cannot prohibit someone from resubmitting an application that was denied or reviewed prior to the effective date of this act. So what that means is, if you have a solar energy, a solar panel modification request today, and your documents say no solar panels, you would deny it, right? Because you can't allow it, your documents don't allow it. So if someone resubmits it after April 1st of this year, you can't say, no, that was denied before, this is the same thing. You are required to re-review it under the context of this act. And the final thing is that you cannot deny a member's application to install the solar energy system because of the identity of the entity that owns the solar energy system or the financing method chosen. So you can't require a specific brand, make, model, those type of things. So the association has no control over branding, those type of things. I don't know how many boards really question financing methods, but that's something you can't do either. I think for most community associations, what you would typically want to see is like, oh, we want this, type. You can't do that. All right, but any standards, let me back up for a second. So beyond that, the association can impose limited restrictions. I'll specify what those are in a minute, but any standards that the association imposes cannot result in the reduction of the production of electricity annually by more than 10% or increase the cost by more than $1,000. So what that means is the act actually doesn't say you can't have a replacement. So a board can still say, we prefer for you to put this on the back of your residence so it's not visible from the roadway. So you can say that's our preference, but you can't require it or deny it if they can prove that their energy production will be reduced by more than 10% if it's in that area. So that's going to be important in a place like Michigan, because depending on how the house is facing, we've already seen them. I've seen a few where people get engineers and they're like, if I put this on the back of my house, I'm not going to, get energy for part of the year, or it's going to reduce it by like 50%. So in that case, you would have to allow it to be on the front yard area, the side of the residence, anywhere that doesn't reduce it by more than 10%. So it's like you can restrict it a little bit. You can say this is our preference, but if it's not going to work for someone, they would be allowed to install it where it will maximize the energy efficiency, and it can't increase the cost by more than $1,000. So however that applies, we'll see on a case-by-case basis, but you can't do anything that would, significantly increase the cost for the installation. All right, so part of the act is also that the policy must establish an application process. So there's specifics as well about what the application must include. So the association can require this information, and the owner who's proposing to install this must provide it. So that is the member's name, the street address of the location where the solar energy system will be installed, the name and contact information of the person who's going to install it, an image that shows the layout of the system on the residence or unit, and a description of the energy system to be installed. So I think this kind of follows with what you would typically have in a modification request. So that's what they are required to provide. And beyond that, though, I think it's going to be difficult for the association to require too many specifics. So really, they just have to tell you where they're going to put it, who's going to install it, obviously who they are and where it's going to go, and exactly what they're installing. So really, it's just I would think of it like any other modification request. And the act also specifically says, and it must be in your policy, that the approval of any individual member, including anyone adjacent to the applying member, is not required to approve the application for the installation. So that means that you can't require a neighbor to say, I'm fine with that. Someone across the street doesn't have to say they're fine with it. So the act specifically says that no neighbors are going to have a say in this. You can't require approval from anyone else in order to allow it to be installed. Now, timeframes. This is very important for everyone to keep in mind if you get one of these requests. So the board must approve or deny the application within 30 days of receipt. So if someone submits one, starting in April, the board has 30 days to review it, okay? Now there's a little bit of wiggle room if you don't have a policy in place yet. So in this 1 year period from April 1st to 25 to 26, if you don't have your policy in place, it gives you 120 days to review it. And I think the reasoning there is just because a lot of boards might not know about this. And if you don't approve on time, the owner is going to be allowed to proceed with their installation. So it gives you a bigger period of time before your policy is in place. But you are still required to review it, regardless of whether you have a policy or not. And if the board does not respond within those 30 or 120 day timeframes, then the application is deemed approved and they can proceed without penalties. So unless the installation otherwise violates the law, they're going to be allowed to keep it. You can't fine them. You can't say it's an unapproved modification. You're not going to be able to take any enforcement action against the installation. And again, I mentioned this earlier, but if something was denied before and then they resubmit it, you do have to re-review it. You can't rely on that prior denial. All right, so I know this is probably a question on everyone's mind is, all right, when can I deny it? What can we restrict? Obviously, like we've been saying, installations on shared roofs or in common areas don't necessarily need to be approved. The association can place any restrictions on it they want within reason, of course, just like any other modification. So, in those communities, you would still review it like a typical modification request. However, if you are in a detached situation, site condo subdivision, the board can deny the application or require removal if any of the following apply, and these are going to be pretty limited. So a court has found the installation violates the law. So obviously, if the court says this is illegal, then okay, then you can require removal. The install solar energy system does not substantially conform with their application as approved by the board. So this is a situation where, you know, they say, hey, I'm gonna put it here, and they go and just do something else. Then it can be considered an unapproved modification, and the association can potentially require it to be removed, or, you know, moved to the location that was approved, of course. And for roof installations, so here's where we get into the substantive specifics. So it can be denied if the solar panel extends above or beyond the roof of the home by more than 6 inches. So you're limited to 6 inches above the roof line, or I guess you could say sticking out from the end of the roof. So it really needs to, you know, be close to the roof and really, you know, conform to the size of the roof. And you can also deny it or require removal if it does not conform to the slope of the roof, or does not have a top edge parallel to the roof line. So it needs to basically lay flat against the roof line. If it's a sloped roof, it can be 6 inches above, but it needs to lay flat. You can't have it sticking up, things like that. So you can require it to at least be, you know, parallel and in line with the roof line. You can also deny it if it does not have a frame, bracket, or any visible conduit or wiring that is not silver, bronze, or black. So there is some color restrictions here. So it's limited to being silver, bronze, or black, which I like because it at least gives some uniformity. And those are typically what's, you know, available on the market. So there's some attempt to prevent things that are, you know, really out of line with the, you know, typical aesthetics of these type of things. So there are some color requirements, but that's all you're left with roof installations is conforming to the slope, can't be more than 6 inches above or beyond, and it has to be one of those colors. That's it. From there, again, the association can have preferred placement, but that's where you have to question, all right, is it going to reduce the energy efficiency? Is it going to increase costs? And if so, it's going to have to be allowed in a different area. Now, this is an interesting one. If it's going to be installed in a fenced yard or patio area rather than on the roof, it does need to be allowed. However, the energy system cannot be taller than the fence line. So if you have a 6-foot fence, it can't be higher than 6 feet. If there's no fence, then there's no height restriction, which I think is a little odd here. That, you know, if you have a fence, it can't go above that. If you don't have a fence, it could, you know, potentially be as big as they want. So that's a little strange, but that's how it's drafted. And then, of course, the owner must comply with code and permit requirements. So if they're not pulling permits, if they're not meeting code, those are also reasons that the association could deny it or, you know, require removal. You know, if someone submits it and they're like, hey, I want us to go do this, and you're like, all right, get a permit, and if they don't, you wouldn't have to allow them to install it. Aesthetics, and again, there's really just those limited colors and you know, restrictions on potentially where it can be placed. And unfortunately, you know, that's about it. So that's really what associations need to keep in mind, is that the policy needs to be very detailed. It needs to include all of these things that I'm talking about. It needs to state all of those things. So again, in your community, it's probably going to be confusing if, you know, you don't need to allow these installations at all, but you still need this policy. So that's where, you know, it'll be up to the board members to kind of educate people. Hey, the law says that it has to state this. And if you look at the act, you know, I'm sure we can circulate like a PDF of it. You could go to owners and say, look here, it says the policy must state, and there's a, you know, big laundry list of things, and you can show people it has to say this if anyone's really questioning you or like why you did this, because it might throw people off, and it might give people the misimpression that they can do something that they can't. So educating the community is going to be important. So, you know, whenever you want to implement this, whether it's, you know, at your annual meeting or however you want to do it, I would plan on mentioning to people, hey, we have to adopt this. It has to say all these things. We're following the law. This is what it has to say. But it may not change how your community handles these things. So the policy, it's required to be made available to all owners within 30 days of when it's adopted or on request. So when you originally adopt it, it has to be distributed to everyone. Now, that doesn't necessarily mean mailed. If you have someone's email, you can email it to them. It doesn't really restrict the way that it's distributed, but it does have to be provided to everyone. And if you have a website, it has to be on your website and available on your website. So if you don't have a website, you don't have to go create one. If you do maintain a website, you are required to post it on there and make it available that way. And then again, it does have to be provided within 30 days upon request. So if someone asks you every day, can I have a copy of the policy? You can't say, I gave it to you before. You're required to give it to them within 30 days of their request. Now, I think in an egregious situation like that, maybe there's a better way to handle it, but you can't rely on, I gave this to you before. You're required to provide it. And let's see.
If someone asks you every day, she'll send them a nice letter.
I guess, yeah, exactly. I mean, at that point, it might be harassment, or I guess you could just wait and every 30 days just send it to them. But the point is you can't say I've given this to you before. If someone asks for it and they're like, I really don't know where it is, then you have to give it to them again. And I'll just mention this now, even though it's on one of the later slides. The act contains a provision where if someone brings a lawsuit against the association for not following the act, for any violations of the act, they're potentially entitled to attorney fees. So, you don't want to be in a situation where you're, having to pay someone's attorney fees because you didn't give them a copy of the policy or something like that. So, it's specifically written in there that it's not required, but they may be entitled to attorney fees if the association is found to have engaged in any violations of the act, or, that applies to not adopting a policy as well. So if you don't adopt one and someone brings a lawsuit and says, hey, they didn't adopt one, they're going to be right if you don't have one, and they can likely get their attorney fees in that situation. So maintenance and repair. So once the installation is completed, what can the association require in terms of maintenance and repair? So it does say that reasonable conditions can be placed upon that, provided they're not more burdensome than those for non-solar things. So if something is, dilapidated, the solar panel is falling off the roof. Obviously, if it's in violation of code, you can require removal for that reason. But I would think about these things as just like any other exterior modification. If it looks bad, if it's falling off, then, you can require them to fix it or remove it. But the one important caveat there is one of the first things I mentioned on this is that you can't inquire into their energy usage. So you can't ask someone, are you still using that? Like if it looks like they're not using it anymore, you couldn't ask them, are you still using that? And if the answer is no, require them to remove it. You're still limited to those aesthetic type of things like you would be with any other exterior modification. So if it's being maintained poorly, there's wires hanging out, those things can certainly be enforced. But I would not tell someone to remove it simply because they're not using it anymore, nor can you ask them if they are. So that's just something important to keep in mind. So really it needs to be maintained in good condition and, in compliance with any state, local building codes, permit restrictions, all those types of things as you would with any other, exterior modification. But as long as you're treating it like other modifications, then you should be fine. Because really the goal, once it's installed, is it says you can't be more burdensome on it than you would be with anything else. So it just becomes another modification. All right. So again, the consequences of violating the act, it does allow, the act says that any member can bring an action against the association if there's any violation. So if your policy does not strictly comply with the act, if it doesn't say something that it's supposed to, if you don't have one, if you're trying to, restrict energy saving improvements and modifications where you can't, if you told someone, no, you can't install a solar panel, and it's not one of those specific reasons, that's a violation. So it's really important to be aware of these specifics and how it applies to your community, because it does provide a cause of action against the association if they violate. And again, there's possible any damages that are incurred by an owner, but it also applies to attorney fees. So if you don't have a policy, maybe the person doesn't have any damages and they just get an order saying you have to adopt it, they can still get their attorney fees. So there still could be financial exposure for the association, even if the owner doesn't have any individual damages to recover. All right, so this is kind of just a conclusion, wrap up. So the key things to keep in mind here are that there's two different areas addressed by the act. That's the energy saving improvements and modifications that can't be restricted within the unit or, owner exclusive use areas. And then there's the solar panels. And as we've talked about, the solar panels can be restricted in some way by the association, but that restriction is very limited. So anything in a governing document right now is going to be superseded by this law. So you don't have to amend your documents. You do need a new policy, but anything that's inconsistent in your documents will automatically be superseded. So you don't need to do anything with your current documents, but you will need to put your policy into effect and follow all of these restrictions once the act goes into effect on April 1st. And again, in any particular situation, especially some of those trickier ones with, electrical modifications and those type of things, certainly reach out to your attorneys and get an opinion on any, specific situations. Because as you can see, there could be penalties and attorney fees if someone is wrongfully denied the ability to do something or install something.
So real quick so we'll go flip into Q&A with Amy here real quick. But before that, I told at the beginning of this training seminar, we're going to do these rather than quarterly, we're switching to a monthly schedule for 2025. So it's always going to be the second Wednesday of every month. We're going to be doing one of these seminars. So the next seminar is going to be by First Citizens Bank, and it's about fraud prevention, how association boards are impacted by insurance policies, E&O policies, directors and officers insurance, that type of stuff. So there's a QR code on your screen that you can register for that. It's also going to be on our website if you want to register for that. And then I will pull this down and open it up so we can have Q&A.
All right, so do we have chat questions? Do you guys have any questions?
Yes.
Yes.
Regarding the policy,
We have lots of questions in the queue.
Okay.
So
All right.
everyone just kind of go in order, be on your best behavior.
Oh, okay.
Go ahead, Bob.
regarding the policy, we use like rules and regulations for certain things. So could we just make a new rule and regulation, whereas this,
Yeah.
therefore, I was going to say no. I mean,
Yeah.
because it's regarding the solar policy act, and that's the only thing we have to address.
Yeah, so it's gonna say, no, but we have to tell you these things.
Yeah,
And there's gonna be like a page or two of things that you have to say just to meet the statutory requirements.
Well, that's what I don't understand, like, where you say you have to have a page or two of all these things that don't apply.
Yep.
Talk to your legislators.
No.
I'm just the messenger.
Well, you had mentioned, you had a slide regarding that, but I didn't see where it really fit into the policy, It was the policy where, the things you mentioned is, you can't restrict certain things. So
Yeah.
why would we start out saying, because we all have shared groups, this does not apply, and then go on and say all this other stuff that's inevitable.
So, I mean, the answer is because you have to. So I know we've been working on these and drafting them, the best way we can come up with to try to make sense of it. So we try to make clear that this does not apply to shared roofs. However, for any, proposed installations, this is the information that we need. So we try to draft it to make clear that this isn't going to be allowed in the community, or, it still needs approval, but, there's, and I have a copy of the act too, I can show it to you as well, or
And we
certainly.
just say, see that kind of, or see the Michigan Energy Policy Act for more information.
I mean, you
To just me, it just makes no sense to put all that stuff out there that's literally
So,
pointless
yeah,
in our regard.
yeah, I don't disagree with you. And that's sort of just a drafting thing when they created this act, that this is how it was drafted. And that's why I kind of mentioned that it was really focused on allowing installation. And that was really the focus of the drafters, I think, that put this together. But it says the policy must include the following statements. So, and there's quite a few of them. I highlighted them all in pink here on these 2 pages. I don't know if everyone can see it, but it's, there's, kind of like a page of text in that I highlighted in pink there. It says the policy must state this. So I think it'd be hard to argue around that in a court, that, it doesn't apply, so I didn't say it. Well, it said you must say that, even if you don't have to allow this installation at all. Yes.
And they mentioned something about putting solar panels in areas like patios. Now, our patios, I think, are considered common restricted elements.
So, right, so the problem is common area is defined as generally accessible to all members. So if it's not generally accessible to everyone, especially if it's a co-owner responsibility area, then someone could potentially put one in their area. Now, they couldn't do it in a way that extends beyond their patio or, modifies common elements. So it may be very impractical, or maybe impossible for something like a solar panel to fit in a patio in your community. So it's not necessarily like we have to allow it, but theoretically, if someone could fit, a little solar panel in their patio that doesn't modify anything else, then they'd be able to have it.
The other thing I was thinking about was common elements, putting solar panels on for the benefit of the association. So that the condo board can benefit by in the use of the common electric.
So that wouldn't be addressed by the act. If it was the association installing a common amenity that serves the community, that is not addressed by the act. That would just be on your documents. So you have the authority to do that, you need approval, etc. So that would just be like any other addition to the common elements.
So, next question, I'm gonna jump chat for a sec, guys. So Joel, you're up.
Thanks. I have a couple, so I don't know if maybe we can do them quickly. First, is there any pending challenges to this legislation that either are known to exist or we anticipate to occur?
Currently, no. So there was a bill that was introduced in the fall that proposed to repeal this act, but it didn't move through the legislature. So when they adjourned their session, that bill essentially is, dead on the floor. So originally there was one introduced, but it is not currently pending because it didn't make it through the session. I don't know if that is going to be reintroduced. There's, obviously a change in the composure of the legislature. So I don't know if that's something that's going to be reintroduced, which would not be uncommon with those bills that didn't get anywhere. So it's possible that could come back up, but technically right now it's not pending.
Okay, thank you. And the second question, and I'll hold it there for my other board members, is the first part of the policy is almost like the Wild West. Anything that you can label as an energy saving measure or item seemingly is permissible for association members to then request and install on their controlled portions of property. So how do we strike an effective balance between some type of aesthetics where, let me share a picture here. Homeowner Bob decides to, install a series of these rain barrels that he's buying them off Craigslist, declaring them as rain barrels and stacking them along the driveway. Or another homeowner says, I don't have room in my backyard for a laundry line, so I want to put it either in the side yard or in the front yard. And it seems that the law affords no restrictions for those sorts of things.
So that's not an easy question to answer. So are you a site condo?
Yes.
Okay, yeah, that's what I thought. So you're going to be one of the communities where you're right. This is going to be more of like the free for all, where because everyone has their own individual lot. The act seemingly says that they can just go do whatever they want. Now, I got to say, The act doesn't say that all the provisions in your governing documents about unsightly appearance or properly maintaining things are also invalid. So if someone has, their rain barrel and it's purple, I wouldn't recommend doing anything about that just because it's not acceptable color. But if something's like not being maintained, it's causing a nuisance because their rain barrel has mosquitoes everywhere. If there are these unsightly, real, more egregious nuisance situations, I would argue that, the act doesn't say that they can just go do those things. It doesn't say that all the provisions about properly maintaining things are also inapplicable. So I think that in those situations, there would be arguments, but I wouldn't recommend pursuing something just because it's wrong color or, the blue one like you showed. But I think to have it enforced, it would probably need to be a, shocking, egregious situation that's really like unsightly. But if it's causing like health and safety issues because of how they're maintaining things, it's probably something that, we could look at enforcing.
Sue. Well, she typed a question in the chat, so I'll read it out. So, for modification requests, given neighbors cannot have a say, what happens? What happens when a board member is a neighbor? So I think she's relating to your comment earlier that you don't have to get approval from a neighbor for like solar panels.
Sure. So, I mean, the board makes the decision by a majority, so it's not like that particular board member needs to approve it or not. They would obviously have their board member hat on, and they would be, making a decision on it in their duty as a board member. It doesn't, the fact that they're the neighbor, they can't look at it that way. They just have to look at it as, this is what the act says. And also because the reasons that the association can deny are so limited that if it checks all those boxes and it, is the right color, it's only 6 inches above the roof line, the board member is really not going to have a legal basis to deny it. So I think that the board's hands are so tied that they're going to have to look at it and look at, does this comply with the law, and follow, that.
I saw another question in here while you were talking about rain barrels. So someone asked, rain barrels on balconies. So if they're allowed to do that, can they put a restriction on a weight limit or something that could potentially cause damage to that balcony?
I would say that they can't say no. They could that might be a situation where the association requires those auxiliary changes. Like, you need to reinforce this balcony and you need to, make sure that this is safe for everyone and it's not going to cause damage. And so that's where those auxiliary changes, I think, would be important, and maybe put it on the color and say, hey, you're going to have to do this in order to have it.
Okay. Tom, you're next.
In a site condominium, can we prohibit the installation of a geothermal heating and cooling system on or under the common elements?
Yes, so you can control the common element modification. So with the heating and cooling system, is it going to be placed on a general common element, or would it be like it's on their unit, but it requires common element modifications to the ground? Because I think if the land that it's on is a general common element, it would not need to be allowed. If there's common element modifications, like they need to dig under the ground or install something in order to have it installed on their limited common element or unit itself, then I think that if there's no impact on the association and no cost to the association, you can say that they're responsible for any damage. But I think that might be a situation where that's an auxiliary change. You might need to allow them to do it as long as they're, responsible for any damage or cost that is associated with it.
Thank you.
But if it's truly on a general common element area, then you would not need to allow it.
Thank you.
Ralph, you were next.
Yes, thank you. I've got a couple of questions. One would be on the solar panels affixed to the roofs. Do we have to allow solar tracking which then would mean that they are installed relative to the slope of the roof, but they change angles in order to track the sun while they're in use. Do we have to allow that?
No, I don't think so, because it has to be, it can't extend 6 inches from the roof line. Obviously, you could allow it if you wanted to, but you would not be required to, because when it moves, it extends over that like 6 inches. So I think that's exactly what does not need to be allowed under this. Again, you could do it if you wanted to, but it's not required to be allowed if it's gonna move and exceed that threshold.
And then the second question would be, and I've got a couple, the second question would be, do we have to allow the homeowner to modify the roof in order to comply with the roof slope? In other words, the roofs on our houses may be such that it exceeds the 30–40%, whatever the recommended slope is, in order for them to get the best sunlight to that. Do we have to allow the modifications of their roof in order to have the slope that they need?
Is this an individual residence and unit, or is it like a detached condo with a common element roof?
It's detached.
So it's detached, but is your roof part of the unit, or is it a common element?
It's
What
part of their
association are
unit.
you
They're
from?
responsible. They're responsible for the upkeep of that roof.
Yeah, this is Golf Ridge, right?
Gulfridge, yes.
Yeah. So because it's their unit and the roof is part of their unit, from what I remember. So you wouldn't necessarily need to allow them to like totally modify their roof. That one is more complicated, because is that an auxiliary change like needed for the installation? I want to think through that and see how different it is, because if it's really going to change the uniformity and the look, if they just modify their roof in order to do this, I don't think that needs to be allowed. I think the problem that you'd have there is, well, what can they put it on a different part of their roof? Is it going to be on the front or in their front yard? Is that any better? I don't know.
Well, I think what comes into play there, and that's why I ask, is you said that if we said, no, you cannot put it in that section because they would have to modify the roof, and they'd have to move it to another area of the roof, and it reduces it by 10%, then we're going to be back into this. Well, then I've got to change my roof on the front side of the house in order to make this happen. Now, if we can make that they cannot violate our rule on that. Is that possible?
Mm-hmm.
I think we need to look into that because.
Yeah.
Okay. Yeah, we should look into that to make sure.
Have to discuss further. Mm-hmm. Yeah, because I think there's going to be a balance there of like, what's worse, them, modifying their roof or them putting it somewhere that is less desirable. So that one, I think we're gonna have to think about a little bit.
Okay, and then the third item is on batteries. The solar panel units can either operate directly into the house, or they have to hook up to the batteries for storage and to be able to use at night or whenever. I know that there's battery backup units that can be put in the house, and there's some that can be put on the outside of the house. Can we restrict that they cannot put them on the outside of the house?
What would it be a battery for?
It would be the battery backup. They would take the sunlight, change it to energy, and it would be energy storage. And then they would use it after 8 o'clock at night, or if it was a storm and the power went out or whatever, they would use their battery backup unit. But there's units that, for the most part, they put them inside the houses, inside their garages, inside their basements and such like that. But there are units that they can put on the outside. Can we restrict that?
I'd say if it's in the general common element lawn areas, then yes. If it's still going to be like within their unit or their limited common element patio area, then no. But if it's going, it's going to be in the middle of the grass here, then that's when you probably can say no to.
Yeah, there's a concern for safety for the adjacent units and the common elements by having the batteries out in the adjacent to the common elements.
Yeah. Yeah, so that's where we gotta just go back to, this does not apply to a common area. We're not required to allow you to install it here. You need to figure something else out.
Okay, thank you.
Next, we'll jump to Robin. Do you need water? Are you good, Amy?
Hi, thank you.
I might grab-
I live in a condo complex where we have common roofs, but we also have carports with the common roof. And my question is regarding an EV charging station. It really hasn't come up yet in our community, but I was wondering how that would apply and what would we need to honor?
So I'd have to look at your documents, but typically a carport is only gonna have the limited common element as the space, and the structure of it and all of the electrical as a general common element. So as long as that's the case, and it's only their parking spot that's a limited common element, you wouldn't need to allow it.
Okay, thank you.
Mhm.
Al, you're next.
I'm sorry, who was that?
You're next.
Oh, great. Sorry about that. I have
You're okay.
two questions. My first question is, I know we have to allow a clothesline, but can we say you can put a clothesline in, although it has to be screened by vegetation or arborvitaes or what have you? So
I would say no, because that
other-
would be, yeah, that would be a restriction on the installation. You're saying, I'm only gonna allow it if you do this, so that would be a prohibited restriction.
Okay, so the drafters of this obviously didn't care too much about our home values, I guess. But on the solar panels, it sounds like you're allowed to put them in the front yard now. I mean, can a homeowner put a solar farm in their front yard without any restrictions?
So that's where we get into, the association can say, we prefer if you have this in the rear yard, but if they can prove that it's not going to be as effective, like it's going to reduce their energy production by more than 10%, then you would need to allow it in the front.
You mean like in the front grass where someone would normally cut their lawn, like in the front?
If it's a site is it a site condo or subdivision, like where they have the lot, is there?
Yes. Yeah, it's a site condo.
Yeah, so it doesn't allow the association to totally like prohibit them in the front. Like I said, you could say, we want you to have this in the backyard, and if they're like, it's not as effective back there, here's my report from my, installers that say this. Then, unless you can prove that, no, it's just as effective in the backyard, then they wouldn't be allowed to use it in the front.
What if it requires a post that goes into the ground deep enough to where they don't own? It's not part of their responsibility. Meaning the mineral
So
right, they
if
don't
it's
own. Yeah. Sorry, go ahead.
I guess we'd have to look at that further and exactly like what their rights are, what relying on to say they don't own it. Again, if it modifies any of the association's property, then it doesn't need to be allowed. If it's like it goes too far in the ground, I mean, if the association doesn't own that property and it's not owned or managed by the association, then I don't think we can rely on that aspect of it to deny it.
Okay. This is like Joel mentioned, this is the Wild West. It's a little crazy. Okay, thank you.
For a community where, it's like a site condo subdivision, that type of setup, it could have big impacts on these kind of things. You're right.
I mean, like if someone wanted 15 rain barrels on the side of their house, we couldn't say no, it sounds like.
Right.
Okay. Thank you.
Mhm.
We had one other question in chat here is, so if an association is responsible for electric, behind the drywall,
Mhm.
electrical wires, would that allow them to prohibit individual units needed to have electrical for like EVs? Like if they had to upgrade electric to add an EV station?
Yeah, as long as it's like really part of the, if it's gonna modify and touch electrical that the association is responsible for, then yes, they can restrict it. That's why I said, like, I can envision a situation where, you know, the owner is responsible for it, owns like from the meter in, and it doesn't have any impact beyond the meter, and it's not going to impact anyone else's electrical, then they would probably need to allow that. But at that point, I mean, the owner's insuring it, they're responsible for it, they're responsible for all the costs. If it is association controlled electrical components, then yeah, you can restrict it. You know, you can require a modification request, require them to indemnify, be responsible for any costs. All those things could be restricted. Mhm. And I mean, that's where it gets hard, that you have to look at the makeup of your community, because I know I've already run across a few communities where they're like, we can't upgrade this without, like, you know, causing a disaster, especially if multiple people want them. Like, their electrical circuit might not allow it. So if you're in a community like that where it really just can't support this even with these upgrades, then it may not be feasible to permit these.
Well, and that's where I think a lot of associations can do, like you were talking about, the solar policy act that you have to send out wouldn't necessarily apply to your community, but when you're sending that out, talk about some of these other things simultaneously, so they're getting communication about maybe EV charging or rain barrels, other stuff, so you're not wasting your time sending out just that.
Well, I still have a couple of questions.
Okay.
I strongly recommend that, you know, if you think that EV installations are going to be a desire in our community and multiple people are going to want them, I'd adopt a policy about it so everyone's on notice of, you know, if you want one of these, this is what you need to do, this is what you're going to be responsible for. And if it requires any upgrades to the system, you're going to be responsible for that too, because those can get expensive. If there's multiple installations in the community, it could start getting pretty hard to upgrade that whole infrastructure.
Regarding the EV, we were going to try and get ahead of and have the policy, and earlier, you know, you mentioned some things, but our thoughts were, we wanted to make sure they were installed by a licensed contractor. We already checked with the city, they have no permitting fee or anything, so there's no help from the city. So we had a laundry list, I think we got from you guys from a year ago, one of your seminars, and plus from another one. So we had a laundry checklist.
Yeah.
And so we were gonna put out a policy that you gotta, you know, follow these things and have it inspected and so on. So that we can do, have a policy.
Oh, yeah, yeah.
Okay. The other thing is regarding, like, you know, we have the attached units. So anyways, but the limited common elements, we already have policies regarding what you can do out there. You know, you can't, you know, like this past election year, we couldn't put out vote for signs and stuff, you know, political signs, bird feeders, all kinds of things. Could we limit or exclude the clotheslines and the rain barrels from limited common elements, which would be the patio, or they have we have a back patio, or you have a side, I'm not even sure what we call it. I guess it's another like patio, but our policy reads that like with the political signs and certain things, they cannot be visible from any common element. And that's how it is. So,
Sure.
So that's what we would throw in, like add clotheslines to the policy and the rain barrels and some of the things we don't want to see. We can do that.
No, because you know, it says you can't have any restrictions on it. So it's really, it's different than, you know, a lot of these rules where you can have reasonable restrictions on like visibility and where you can put things. Any restriction on it in a cone or unit or exclusive use area is going to be totally invalid for those clotheslines and those type of things. So if that was in your policy, it would be totally unenforceable.
And I'll flip back to Joel one more time, and then I want to try and wrap up. I don't want to keep Amy here all night, so.
Yeah, thanks. Just a follow up based on the discussion about 10% and energy saving measures. If in the Wild West, if homeowners do want something that's a little squirrelier, it seems, can we require them to put it within their whatever space they have in the backyard first and demonstrate that it won't work there before we permit it on the sides or the front of the property? So we're not saying you
Yeah,
can't
there's
do it.
nothing. Right. Yeah. So that's where the act doesn't say that you have to just allow it anywhere. It says you can have reasonable restrictions on it, but it can't reduce the energy production or increase their cost by more than those amounts. So you could say, we want you to put this back here. But if they get a report, and I've already seen them saying like, look, the energy that's going to be produced in this location is this, and it's going to reduce its, energy production by 50% if I put it back here. You can't make them do it. You can't say, no, you can't put it in the front yard, because they're going to be allowed to have it. So in the first instance, you can say, this is what we want you to do. But if it doesn't work, then you would have to allow it somewhere else. So with the solar panels, especially, the first thing is everyone wants them on the back of the house, right? So they're not just on the front of the house. So we have a lot of associations that want to, say it should be back there unless, it's not going to work.
So you could have
But
a
that
requirement
that might increase the co-owner's cost. So I don't think the act allows us to say you have to put it back there, and then if it doesn't work, you can put it in the front.
It puts the burden on the
Yeah,
homeowner to show that the cost is that there is additional cost.
Yeah, no, that's a good point. I mean, if it's going to be more expensive to install it where the association wants it and they come to you and they say, look, this is my cost here and this is my cost here, and it's more than 10% different, then, you're absolutely right that you might not be able to do that. So it's both. It's the energy production and the 10% threshold for the cost. But yeah, like I said, there's nothing prohibiting you from saying in the first instance, this is what we want to see. And then it would be up to the co-owner, like Joel said, to prove this is why that doesn't work.
Perfect. Do you want to
So-
say more, Mary?
So
If
can
anyone
you,
wants
can you
to-
wrap up for us what restrictions we can have within our common areas? In other words, our houses in the Gulf Ridge, Villa Homes, the house is on a known dimension, and that's it. The rest is common areas. Do we have to allow a rain barrel that sits on the common areas that extends out 2 feet from the house? If the envelope of the house defines the unit and everything outside of that is the common areas? Like the clothesline, do we have to allow it to be on the common areas? If they say, well, I'm going to have one, whatever, I'm going to have one and I'm going to put it on the common areas because I'm allowed to have one. Can we restrict that and say, no, we have the right to keep you from not having it on the common areas, our defined common areas?
Yeah, so I think for your association, you're 100% right, because you're not a traditional site condo where the site includes any yard area for the most part, right? Your sites are just the residence. So if it's outside of that unit boundary, I know that like you just have general common element lawn area. So for your community, you would not need to allow it outside of the residence, aka the unit, because that is a general common element area. I will say that there are a lot of more traditional site condos that the yard is part of the unit itself. And in those communities, it'll be much different. But for your community, you will have a lot more control and restriction on those exterior things because it's general common element.
So we won't have much of the Wild West. We'll have some kind of West, but not Wild West. Thank you.
Yeah, I think you're going to see probably more of the solar panels on the roof, but the more exterior things, you're going to have more control over those than some of the other folks here today.
Okay.
Okay.
How
I
many
don't
different condo associations have we got on the phone here today? What I'm looking for is there some way that we can look at cross develop some of these things so that we don't miss some of the elements? I mean, we're going to be a little bit different in Gulf Ridge, but the other elements, maybe if we can share some of the the common issues.
Yeah, so there was about 40 associations on here. But to Amy's point earlier, it's really about each governing document for each association. So there's some general templated stuff that's fairly similar across most of the associations, but the attorney really needs to look at your specific documents to see if there's any weird caveats in there.
Yeah, because like I said, a lot of this is standard because the act says, okay, your policy has to say this, but when it comes to what you can actually restrict in your community, it really is going to be different for every community. So we really need to look at, all right, what's your general limited common elements? What's your unit to refine exactly what you would have control over and how the policy should be drafted, even though a lot of it might be just required statutory language.
Awesome. I don't see any other hands raised or any other questions, so I will say we wrap it up from here. Thank you, Amy, for
Thank you,
joining
yeah.
tonight. I mentioned in the chat, but we'll distribute the presentation to everyone. And if you have any other questions, Amy's contact info is in there. Feel free to reach out to her. And thank you. We'll see you
Thanks,
next time.
everyone.